Hello, and welcome to the civil litigation page. Before we continue, there is a disclaimer. The information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise that you consult with an attorney. Now I will be discussing the civil litigation process. A civil case usually begins when one person or business asserts or claims to have been harmed by the actions of another person or business. When the plaintiff files a complaint, they have initiated a lawsuit. In the complaint, the plaintiff outlines the facts along with legal theories and then makes a request for relief. In the complaint, the plaintiff might ask the court for damages, meaning money to be paid to the plaintiff for any harm suffered, ask for an injunction, which is a court order to prevent the defendant from doing something or to require the defendant to do something, or ask for a declaratory judgment, which is a court order stating the party's rights under a contract or statute. Eventually, a judge or a jury will determine the facts of the case. Basically, they will figure out what really happened and apply the appropriate law to those facts. Based on their analysis of the law and the facts, the judge or jury will make a final judgment, sometimes also called decision or order, and decide what legal consequences to implement. The types of cases in a civil court are tort claims. A tort is a wrongful act that causes injury to someone's person, property, reputation, or the like, for which the injured person is entitled to payment. Some examples would be personal injury, battery, negligence, defamation, medical malpractice, fraud, and many others. Breach of contract. A breach of contract case usually results from a person's failure to perform some term of a contract, whether the contract is written or verbal, without some legitimate legal excuse. Examples include lawsuits for not completing a job, not paying in full or on time, failure to deliver goods sold or promised, and many others. Another is landlord-tenant. Civil courts handle disputes between landlord and tenants, such as cases where the landlord is trying to evict tenant or the tenant has moved out and is suing the landlord for the return of their security deposit. Stages of civil case start with pre-litigation stage before you file a case. This is where you will evaluate whether or not it is in the best interest for you to sue. Filing a lawsuit is time-consuming, can become extremely expensive, and can have major consequences. Take the time to figure out if you have a good case and a chance of winning. Maybe there's a possibility in resolving the dispute without having to sue. If, after all, you do decide to sue, take the time to plan your case very thoroughly and gather as much information possible to help you win your case. Then the pleading stage, filing a complaint or responding to a complaint. This is where the lawsuit is initiated by way of filing a complaint with the court, which outlines the claims against the party being sued. Once you file a complaint, you must also serve the other party that you are suing. Or if you are represented by an attorney, then you should serve their attorney. Or the alternative, you are being sued and you have been served with a complaint, in which case you have 30 days to file a response to state your defenses or attack the complaint. Then is the discovery stage, which is getting the information you need. This is your chance to obtain all the information that you think you will need to win your case. During this stage, parties have the chance to learn what evidence the other side has. The parties are required to exchange certain documents and information. If there is other specific information that you need from the other side or from a third-party witness, you can use the discovery tools to try and get it. Then the pretrial stage. This is where the filing and opposing motions happen. The pretrial stage is when the parties try to focus on the issues in the case and get rid of claims and the defenses that don't need to go to trial. In this stage, both parties file motions, which are written requests that ask the judge to take some action based on a party's legal argument. Motions are powerful tools. The judge's decision on a motion might win or lose the case for you. Then is the trial stage, which is your day in court. During this stage, the parties might attend a pretrial or a settlement conference, prepare for trial briefs, subpoena witnesses, and generally get their cases organized. Then there's trial, where both parties present their evidence to the judge or jury, and the case is finally decided. Lastly is the post-trial stage. After trial and appealing, this stage is where the parties address the judgment that was entered after the trial. The winning side will make sure the judgment entered and noticed and might try to recover attorney's fees and court costs. Both sides might try to alter the judgment in some way, or they might appeal the judgment and ask the higher court to review the case. Thank you for visiting this page, and I hope this information has helped.